Hello, welcome to the GRadulting Workshop Series. At today's session, we will answer the question, do I need a will or an estate plan? My name is Debbie McCuskey, and I am the coordinator of services and programs for graduate student legal aid, and I use she, her pronouns. I'm happy to see folks who are joining us on Zoom, and I also welcome those who will be viewing this on YouTube. This session is being recorded and automatic closed captioning has been enabled. Please be aware that you may experience errors related to accuracy, synchronicity, program completeness, and attribution. So for those who have not attended a GRadulting workshop yet, you may not know that the GRadulting Workshop Series is just one service offered by Graduate Student Legal Aid. Our team provides free services to UMD graduate students in 4 service areas. First, legal consultations are provided by our director and attorney, Zach Mundy. Legal immigration consultations are provided by an outside immigration attorney. That is her specialty. That's all she does. And she meets with our students once a month. Advocacy consultations are provided by our grad student, Tara Johnston. She helps students who are charged with a violation of the university's code of conduct or the code of academic integrity. Notary services are provided by me. I do that one day a week on Thursdays. And right now, that is the only service we provide in person. All of our consultations are on the phone, email, or Zoom. And Tara's going to post a link in the chat if you want more information about who we are and what we do. So here's the plan for our workshop today. Our speaker has requested that you hold your questions until the end of the presentation. So at that time, we will invite you to post your questions in the chat and just post them to everyone. Near the end of the workshop, we will post a link to our 6-second survey. So please take 6 seconds to respond. We only ask a few questions, and your feedback helps us maintain and offer high quality workshops. And later this afternoon, we will send you an email that contains the PowerPoint presentation, a link to the recording for this workshop, and the registration link for next week's workshop. And the topic for that is, how do I negotiate my salary? That'll be a great workshop. Hope you can make it. All right, let's get down to business now. Wills and estate plans. So I am going to share a poll with you, and we just ask a couple of questions. There we go. So please take a minute. You will be anonymous when you reply. Have you reviewed a will? Do you have children? Do you own a house? So thanks to everyone who's responding. Okay, looks like we're good. All right, I'm going to share the results. And it looks like no one has reviewed a will yet. Well, we will take care of that today. Some of you have children and some of you own a house. So thanks so much for helping us get to know you a little better. So it is now my pleasure to introduce our speaker. Her name is Danielle Cruttenden. Did I say that right? No, Cruttenden.
Cruttenden, that's okay.
I apologize.
No worries.
She is a principal with McNamee, Hosea. It's a local law firm that has offices in Greenbelt, Annapolis, and Alexandria. And for the past 30 years, attorney Cruttenden has focused her practice in estate planning and estate and trust administration. She helps clients develop estate plans that address their unique needs. She has experience in drafting numerous estate planning documents, including wills and revocable trusts, durable powers of attorney, advanced medical directives, and more. She also helps families settle the final affairs of a deceased loved one. So we are privileged to have such a capable and experienced attorney with us today. Welcome, Danielle.
Thank you, Debbie, for that introduction. And it's good to be with all of the viewers. I will be, as Debbie said, talking a good bit about what a will is and what it does. So that the polling you did, Debbie, was very helpful. It's good to also know that some of you do have children or own a home, because certainly a will is relevant for those of you that do, as well as those that don't, and we'll explain why in just a minute. So actually, I was trying to just my screen will not advance. Let's see.
You mean your PowerPoint isn't advancing?
It was earlier.
Why don't you stop sharing your screen?
Okay.
And then try to share it again. And then if that doesn't work, I can do the sharing.
Okay. Stop share. Okay.
Okay.
Nope.
Is it working now?
No, I just
Okay.
need to be locked on that first screen.
Okay. Why don't I share the presentation on my screen and you can just tell me when to advance?
Oh. Okay.
Okay. All right. Okay. Can you see that now?
I can. I hope everyone else can. Okay.
Right. Let me try to turn it into a slideshow.
Wonderful.
And let me make sure it will advance.
Very
Yay!
good. Okay. Thank you, Debbie. Okay. Don't know what went wrong there. Okay. So if you would be so kind to go ahead and just advance to that's me, guys. And so there is my email address. I'm happy to take questions by email as well after the presentation. Moving ahead to the next slide. I wanted to just cover, the purpose of this, as was said, we want to talk about why is it important to have a will, and why there are, other legal documents that you should consider having. These documents are intended to take care of your personal and legal affairs at a time of illness and at death. I realize this is not a happy topic to talk about, but nevertheless important. We are going to cover 4 parts. The first part will talk about wills. The second part will talk about what we call non-probate arrangements, and I'll describe to you what probate is all about. The third part will address the financial power of attorney, and then the last part we will talk about health directives. Okay, next screen, please.
Just a second. I just dropped my mouse. There we go.
Okay. So first of all, why plan at all? So if you do no planning at all, what happens upon your death is that any property that is solely titled in your name, meaning you are the only owner of the property, no joint owner, no beneficiary designation, that property is going to pass according to what are called the laws of intestacy. What that essentially means is that if you don't have a will, the state of Maryland has one for you. And it may direct your property to people that you really would not intend or want to receive the property. The laws of intestacy dictate who receives your property if you don't have a will. So by planning, you can, of course, state who you want to receive that property that's titled in your name. If you don't have a will, the law is also going to dictate who is in charge of carrying out the distribution of your property. Whereas if you have a will, then you get to choose who's in charge of distributing your assets at the time of your death. And further, you can include a provision that says that that person can serve in that job without having to post what's called a bond. A bond is something that the state would require to ensure, it's a surety bond, to make sure that person carries out their job, but it requires them to spend the money to basically provide this insurance, and it can be expensive. So for example, if you have an estate, that has assets of, $50,000, well, then the state will require your personal representative to post a $50,000 bond, and that can be rather expensive. So with a will, you can say that the person is allowed to serve without a bond. In Maryland, they still require the posting of a nominal bond in all cases, except small estates, and the bond premium is $100. So much more cost effective to your executor, and that's what we call a personal, we call them personal representatives in Maryland, but you might think of the term executor. So much better if you can say in a will that your personal representative can serve without this bond, this expensive bond. If you don't have a will, then the law is also going to dictate or is going to control who becomes the guardian of any of your minor children. In a will, of course, you can then express who you want to be the guardian of any minor children. In a case where maybe you don't have a financial power of attorney, then if you become disabled or, just whether it's mental disability or physical disability, someone's going to have to go to court and ask for a judge to appoint a guardian over your person and your property. That is a very time-consuming and expensive process, and it requires the court-appointed guardian to not only have to post a bond, but to account and report to the court on at least an annual basis. So that gets pretty burdensome and expensive. If you have a financial power of attorney, you can avoid that guardianship almost entirely. There might be still situations where a court says it's still necessary that you have a guardian appointed, but it's helpful to have a financial power of attorney. And also, by planning with a medical directive, you can control who makes your medical decisions for you instead of relying on the law to designate who does that. So part one, we're covering, again, what a will does and what it does not do. So I mentioned to you that it really only directs property that's titled solely in your name. So if you have a joint account, for example, with your spouse or even your parent or a sibling, the will does not govern what happens to that jointly owned property. Jointly owned property automatically belongs to the surviving owner of that property when you die. But for example, if you have a bank account that's in your sole name or a home that's in your sole name, then that will is really going to be the document that controls what happens to it when you die. It doesn't control things like life insurance policies that very often have a beneficiary named. The will directs how your debts get paid and how taxes get paid. And of course, that can be a very important issue that needs to be addressed upon death. So for example, you might have a mortgage on your home, and then you want to be able to specify, well, who pays that mortgage when you die? Does your estate pay that mortgage? Perhaps with life insurance that you direct be paid to your estate. And you want that insurance to be used to pay off that mortgage? Or do you want your beneficiary who receives the house to take it subject to the mortgage, meaning that beneficiary would take over the mortgage payments? And as we just mentioned in the prior slide, the will allows you to name who's going to be in charge of settling your estate through that probate, what we call the probate process. The probate process is in fact the legal process that has to take place after you die and your will is submitted to the court, and the court oversees the administration of the transfer of property out of your name to the beneficiaries that you name in your will. The court makes sure, of course, those debts and taxes are paid. They make sure that all the property that is titled in your sole name is properly accounted for. And this process takes generally at least 6 to 9 months, sometimes 12 months to finish. This will also, of course, specifies who might need to be serving as guardians for any of the minor children you have. And importantly, if you need to have maybe a trust established in your will to receive your funds to take care of a minor child or a disabled individual, a will is where you can put that kind of trust language in. Next slide, please. Okay, so what are the requirements for a will to be valid? So it must be in writing. It must be signed by you in the presence of 2 witnesses who actually watch you sign. So typically we do this with, the person, the client signing in the presence, my presence. I usually will serve as one of the witnesses, but we all have to be together to watch each other sign. You're not required to have a lawyer to do a will, but it can be helpful, especially in cases where there are blended families. What I mean by blended family is, prior marriages or children from prior marriages, or where there are beneficiaries, family members who have disabilities and might need some kind of trust created in the will to take care of them at your death. Next slide, please. So once you have a will, where should you store it? Because it's really important, of course, that it can be easily found following your death. The Maryland Registers of Wills, there's a register of wills in each county and throughout the state, and our registers do accept for safekeeping your will for $5. They will store it in a vault, or among their other wherever the safe places that they have in their local Register of Wills office. Another place that you can store a will would be at home, preferably in like a fireproof box or a safe. You would want to make sure you always tell your appointed executor where the will can be found. Again, the executor is the person that you're naming to carry out that probate process, the person of your choice. Some attorneys will store wills for their clients, and then other people do prefer to place them in a safe deposit box at a bank. But if you do that, you do need to make sure that someone else has access to that box, because otherwise, upon your death, if the bank learns that you have passed away, they will not allow anyone to access that box unless they have authority to do so, or they will require a court order to get in. Next slide, please. So sometimes questions I get are, well, what if I have a will here in Maryland and then I move? Am I going to have a new will done? And the answer is not likely that you'll have to have a new will done. A will done that's properly executed here in Maryland is valid in other states. I always do tell clients, though, that some states' laws will differ from Maryland law. So it's always a good idea to still have it reviewed by a lawyer in another state to make sure that there aren't any changes that need to be made. Next slide. How often does it need to be reviewed? So once you have a will, do you need to have it changed or reviewed at any specific intervals? And our general rule of thumb here is we try to send a letter out to all of our clients every 3 years, just to touch base and to point out that if they've had any change in their life, like maybe they're now married, maybe they have more children, maybe they've acquired more assets. Laws change, certainly when it comes to things like death and inheritance taxes. So it is always a good idea to just have things, looked at every 3 years, because your life changes and the laws change too. Next slide, please. And then I get the question of, well, should I have a trust? In this case, I'm not talking about, a trust for minor children, that is, or a trust for a disabled beneficiary. And we know, and I've described to you, that a will can contain such trust. Those trusts, because they don't exist until you die, are called testamentary trust. But some people like to create trusts during their lifetime, and they're called revocable living trust, and they're designed to avoid the probate process. And so there are occasions in which it's appropriate to consider having a living trust. Generally speaking, it's at the point in time when you're going to have acquired more assets, because they are more complex to draft, and you retitle assets in the trust. And very often they're used, to help with kind of estate tax planning. So at some point, it might be appropriate, as you acquire more assets over your lifetime, to consider having what's called a revocable living trust. And in that instance, you actually appoint a trustee who can manage the assets upon your disability or upon your death. You generally serve as your own trustee of your revocable living trust while you are alive, and as long as you are healthy and able to do so. So next slide. So non-probate arrangements. So I described to you that probate process involves having your will submitted to the we call it orphans court in Maryland. That's our probate court, and it begins this time period that lasts at least 6 months, more often 9 to 12 months, for the overall process of transferring assets out of your name into the name of your beneficiaries to be completed. And the reason it takes that long, by the way, is the law gives your potential creditors and beneficiaries an opportunity of at least 6 months to either file claims against your estate if they think that they're owed money, or to maybe contest your will. So people are very often interested in ways of kind of avoiding probate. And so some of the things that we do in conjunction with a will is looking at how can we also have property avoid probate. So as I said earlier, that jointly owned bank account that you own with your spouse or a parent or somebody else, that's not going to go through the probate process. That's going to go directly to the joint owner. Life insurance and retirement accounts. Maybe you have a Roth IRA or a traditional IRA. You want to have beneficiaries on those accounts. Have those assets go directly to the named beneficiary. It's possible to have bank accounts set up that way too. A bank account can be just in your name, but it could have a payable on death, provision that names a person, to receive the account directly at your death without having to go through probate. It's also possible in Maryland now to name a beneficiary of your car. I've put there a link to the Maryland Motor Vehicle site, which allows you to do that. It is a form that you would just complete and file with the MVA office. For this to work, though, there can be no liens on the car. You must own your car outright for this to work, because clearly, as long as you owe money on your car, the lender is going to have something to say about getting paid in full before they would allow the vehicle to be transferred to your beneficiary. Living trust, well, we just talked a little bit about that in the slide that we just, the prior slide. Living trusts are ways of also avoiding probate, but they're generally more complex and done for individuals that have acquired a number of assets. There's something also called a life estate deed that you might want to be aware of for people that own their home. There are ways of putting like a beneficiary on your house. Here again, if there's a mortgage on the house, it's complicated by the fact that the lender may need to be contacted and their consent obtained to allow this to be done. But life estate deeds allow you to name a family member to receive the house automatically upon your death. So they're more often used for older individuals who have already paid off their mortgage and are just looking for a simple way to get their home to their family members without going through probate and without having to put together a living trust. I just thought you should be aware of some of the different ways to avoid probate. Next slide, please. So one of the other documents that is really important to have as part of your overall estate plan is a financial power of attorney. And this is whereas a will is a document that takes place upon your death. A financial power of attorney is something that you have while alive. And in fact, it terminates upon your death. So the financial power of attorney is only good for as long as you are living. It's intended to address a situation where you're living, but you're not able to take care of your own affairs. Maybe you are in the hospital temporarily or more permanently, and you need someone to make sure your bills are getting paid, your tax returns are getting filed, maybe benefits need to be applied for. So it appoints an agent. It's a person that you are giving authority to manage your affairs because you're not able to do it yourself. Having said that, these powers of attorney can actually be written to be effective immediately without there being some proof of your disability, or you can say that they're only, the agent's authority is only operative if like a doctor has signed some type of opinion that says you're disabled. This doesn't ever give up your own authority to control your own legal affairs. It's really just naming someone else who can do it as well. And these powers of attorney can only, of course, be signed by someone who does have their legal capacity. And you might think it's funny I even put that out there, but you'd be surprised at how oftentimes we're asked to consider putting together a power of attorney for someone to sign whose competency is already kind of questionable. So they can only be signed by someone who has their legal capacity, which is why it's important to think about getting it done now, not after something has happened to you. And it is signed and acknowledged before 2 witnesses and a notary public. Next slide, please. So as I mentioned, it can be effective immediately when you sign it, or it can say that it only springs into effect at a later time. For example, when a doctor says you've lost the ability to make your own decisions. Sometimes they're effective. Maybe you want to say it's effective if only 2 doctors say you've lost your ability to manage your affairs. I personally recommend that they be effective immediately if the client is comfortable with that. I recently had an experience where the client's power of attorney was effective only with 2 doctor certifications, and it took us a really long time to get that second doctor certification. A lot of doctors don't like to get in the middle of these things. Competency is sometimes not a black and white thing. Sometimes there's a lot of gray area where a person seems perfectly competent at a certain time of day and not so much later. So I personally like them to be effective immediately. Of course, it's very important that you're picking your agent as someone who you have ultimate trust in. This person obviously is someone who not only needs to be trustworthy, but is, going to always act in your best interest. They're required to, as a fiduciary. They can be sued if they don't act in your best interest. You're typically appointing your spouse, another family member, a trusted friend. You can also name an attorney if you really don't have someone that falls into a trustworthy kind of category. And you can name more than one person. You can have co-agents. And it's always important, I think, to name a successor in case the person you've selected is unable to fill that responsibility. Next slide, please. So we need to go back about 4 slides, I think, Debbie. So health directives fall into 2 categories. We can stop there. Okay. So there's kind of two health directive forms. One's called the Advanced Medical Directive, and the other one's called I call it the MOLST form. It stands for Medical Orders Life-Sustaining Treatment form. So next slide, please. So what's the difference between these 2 things? So an advanced directive, and you can have both, by the way. An advanced directive is that a legal document that's intended to speak for you with respect to your medical care, your health care, when you can't do that for yourself. It can contain what's called a healthcare power of attorney, where you name a healthcare agent, much like your financial power of attorney appoints a financial agent. This is where you appoint a healthcare agent to make decisions for you when you can't do so for yourself. And that could be any kind of healthcare, right? It could be just whether you receive surgery, whether you've received, I don't know, where you're receiving care, what hospital, what doctor. It also may, but it's not required, to contain what we call a living will. A living will is that document that specifies what kind of treatments you may or may not want, maybe in like an end of life situation where there's terminal illness, or an end of life, an end stage condition, they call it, or a persistent vegetative state. So, do you want life-sustaining treatment, or do you not want to be kept alive artificially for some protracted period of time? That's what we call a living will. So that's what an advanced medical directive does, right? It appoints a healthcare agent, or it can. You can choose just to do a living will if you want. And it contains the living will component. So again, it allows you to choose what parts you want to complete. You're not required to complete all of them. The MOLST form, on the other hand, is actually a medical order. It must be signed by a physician or a nurse practitioner or a physician's assistant. It's going to contain medical orders about treatments, much like we just kind of discussed, CPR, ventilators, feeding tubes, etc. But it's based on your current medical condition. It's something that's already happening, happening now, something maybe you've been diagnosed with that you need to address based on that medical condition you have now. What kind of orders do you want to have put into place to make sure they're carried out? Next slide, please. So with an advanced medical directive, it must be signed, and it must have a date, and there must be 2 witnesses. The witnesses may not benefit from your death. So you must have at least one kind of independent witness. You can't name your healthcare agent and then have that healthcare agent also serve as one of the witnesses. So it's best really just to have your two witnesses be totally unrelated to really you personally. Having just someone unrelated to you serve as witnesses. Notary is not required, but could be one of the witnesses. An attorney is not required, but can be helpful in understanding and completing the form. If you have an out-of-state advanced medical directive, they're recognized here in Maryland. Next slide, please. So sometimes we get asked the question, okay, if you have an advanced directive, why would you also need a MOLST? Well, like I said, that MOLST form is really specific to a condition that you have now, whereas the living will that's inside that advanced directive is really just kind of direct. It's intended to cover some kind of hypothetical future medical condition. If I was in this catastrophic accident and if I was at end of life, this, I don't want to be hooked up to a ventilator. So that's the difference between those two forms. Advanced directive is more hypothetical future issue. MOLST form is, okay, this is a condition I have now that I want some medical orders in place. And then if you specifically would not want CPR, if you had some type of, terminal condition and you don't want an EMT arriving on the scene and giving you, CPR, that's called a do not resuscitate order. It has to be on a MOLST form. You can't put that in an advanced directive. Next slide, please. So here's just some places to go to get information, and also even just to get some of these forms. So the People's Law Library in Maryland, websites there gives a lot of good information about wills. You can also go to that same site and look and see what a Maryland form power of attorney looks like. There are two kinds. One is I call it the short form, and one is the long form where you are very specific about what things you want to authorize your agent to do, so you can kind of pick and choose, whereas the short form is kind of more general in terms of the things that an agent's permitted to do for you. You can see what the advanced medical directive looks like at the Maryland Attorney General's website, so I put that up for you there, as well as the MOLST form. So I hope those are helpful sites. So I'm happy to take questions.
All right, folks, time to put your questions in the chat. The first question, I think you already answered. If you move, do you have to change your will?
Yeah, so no, you want to probably have it looked at, but it's still a valid document when you move. It just might be that you want it to be updated to reflect some law that's in the state you moved to.
The next question, well, perhaps it's a comment. It says, sounds like something that could be covered under the full faith and credit clause, maybe?
Yeah, it's comedy. I think it's the comedy clause. It's the same idea. Like, we recognize, like, wills that are validly executed in other states. You move to Maryland, we recognize them, vice versa.
Okay. Next question. Can witnesses be next of kin?
Yeah, they can be. Is it a good idea? Generally not. Sometimes we are in situations like certainly during COVID, when executing documents, just became really a difficult thing. And we had to have a witness, but generally it's best not to have witnesses be your family members, because someone can maybe challenge the validity of the will, assert that you've unduly influenced them to leave you, all of their estate. Best
Right.
not to.
Understood. All right. Any more questions?
Yes, could you explain again what you meant when you said the person who's going to be the your assigning power of attorney, that person has to have legal capacity. Could you explain that again?
Yeah, so, well, I guess yeah, so we call them an agent, and certainly you want to, if you're going to name an agent, you want that person to have their legal capacity. But what I was really trying to get across is you need to sign a power of attorney during a period of time where you are well and healthy and have legal capacity, because all too many times we as lawyers get a phone call and ask that these documents be prepared at a time of crisis where the person is
Yeah.
already in the hospital, already on pain medicine. And I'm trying to legitimately get a document signed by someone who's arguably not altogether with it because of the pain medicine. And it's miserable and it's stressful. And so let's not wait until a crisis happens to do a power of attorney or a will. And I've done that too, and it's not fun. And it's not fun for the lawyer. It's not fun for the family. And often the family is having to pay me twice what I'd otherwise charge because I'm having to actually go to the hospital and stand around for 2 or 3 hours while we're waiting for patient advocacy to be able to send us some witnesses who can, witness the signing of the document. So let's do these things when you're well, not when your capacity is questionable.
Okay, so that term legal capacity is being used in a general sense. It's not an actual sort of doctrine, legal definition.
That's a great question, Jared. In Maryland, it also means you have to be 18 years or older for you to have you have to be also of age. You have to be 18 years or older, and you have to be mentally, have mental capacity.
Okay. And then my second question was, could you explain what just review what the probate period was again, and why
Yeah.
you said we want to avoid it in some cases?
Yeah. Well, first of all, I want to make it clear that always have a will no matter what. Even though, yes, having a will means your estate will go through probate, it is better to have a will than not because you want to control who gets your assets. But the probate process does take at least 6 months because the law requires that people have an opportunity to file a claim against your estate. So let's say, before you died, I installed a new roof on your home, and you didn't pay me everything I was owed before you died. So the law gives me 6 months to file a claim against your estate to say, hey, I didn't get paid for that work that I did on this decedent's home. So that is why a probate estate must stay open for 6 months before it can close and the assets distributed to the beneficiaries. And so, that can be hardship for, imagine, a spouse who might need money right away, or another family member. So having some non-probate arrangements in place too, where you name a beneficiary on an account, allowing that money to go directly to that family member can be, helpful. So that family member is not having to wait necessarily 6 months to get the funds that he or she needs. So, still have a will, but, recognize there are other ways to have assets transfer. And you'd be surprised how many people, they sign a will and then they think that when they die, everything just magically gets transferred according to the will to their beneficiary. And I'm like, no, there's actually a process that has to happen. Like, after you die, your will and your death certificate go to the court, and the court says, okay, we're reading the will and we need to appoint this person as your personal representative. And then they're charged with the responsibility of having to account to the court as to what the assets were, make sure those creditors who file claims get paid. And then we allow, the court allows the assets to transfer after that 6-month period. But it's really more like 9 to 12 months, to be honest.
Okay. So I mean, are there I guess restrictions on what you can have a non-probate agreement with besides or is it anything that you own outright, or there's no lien or mortgage or anything on, you could potentially have a non-probate agreement to kind of expedite that process once you die?
So it's not so much a it's not so much a non-probate agreement as recognize that when you have financial accounts, whether it's a bank account or a life insurance policy, you will be asked whether you want to name a beneficiary, or you could ask, may I put a beneficiary on this account? And generally there's a form that the financial institution will provide you with that allows you to name a beneficiary. And then for real estate, for things like houses or homes, if you own a home with a spouse, then the house is going to belong to your spouse when you die. But if you don't have a spouse and you own it just in your sole name, then it's going to be your will that dictates what happens to that house. Again, life estate deeds can be considered. I would strongly encourage you to use a lawyer for that, because life estate deeds are complex. Living trusts are often used to put a house in to avoid probate. And you can typically get the consent of the mortgage company to allow you to transfer a house to a living trust to avoid probate.
Okay, that was actually kind of touching on my last question, which was kind of about the concept of a living trust and what they're used for. So I'm kind of thinking, is it similar to how an individual who operates a sole proprietorship uses maybe an S corporation or an LLC to kind of make what they're doing kind of a legally separate and protected in some ways? Is that what a living trust does in a sense?
In a sense, because, much like if you create an entity, like a business, you're transferring the ownership of that property out of your name into the name of that business. So it's the same thing with a living trust. You're taking the property that you own in your name and you're going to transfer the ownership to the trustee of that trust, who, by the way, is often you. But it is a actual change of ownership. You don't own it anymore. Your trust owns it. And therefore, what happens to that property from the time you transfer it to the trust is governed by what the trust document says. And the trust document's going to say who gets that property when you die, so that it doesn't have to be subject to that probate process that the court oversees. So much like with a business, the business operates according to the business documents. So with the trust assets, the assets in the trust are governed by what that trust document says. Recognize, of course, if you own a business, if you own like an LLC or something like that, that LLC interest also might go through probate, unless your operating agreement has other provisions that say that it goes to somebody else upon your death.
Okay. So what are those oftentimes used for, the living trust then, like with the trustees where you're your own trustee? Like what do you see most often is that being used for?
Yeah, real estate, so certainly residential real estate, rental or investment real estate, investment accounts, clients that have stocks, bonds, mutual funds, business assets like an LLC, interest, those kinds of assets we put in the living trust. Bank accounts too. I mean, we do put in bank accounts, savings accounts, but we don't usually create a living trust just because you have a savings account. It just, the cost, I think, of doing that is, it doesn't justify usually, you know, the cost of setting it up is usually not justified by just having a savings account, unless of course it's a rather large savings account, which could be.
Okay, thank you.
All right. Deanna has her hand up. Do you want to unmute and ask your question now?
Sure. So,
Great.
hi.
Hi.
Hello.
I'm actually a trustee, I guess. And so I'm just curious, like if my father were to pass away and it says that like then I would get it, what do I do if I'm avoiding probate? Like who do I go to enact a living trust?
Yeah, so if you are named as a successor trustee, which sounds like you are, it's really helpful, Deanna, just even if you have a consult with probably a trust attorney, just to understand what your responsibilities are at that point in time. Because not only are you responsible for, of course, making sure that the property gets distributed to whoever the beneficiaries are that are named in the trust, but you're also going to have the responsibility of making sure tax returns, if any, you know, have to be filed for the trust. There might be income taxes to pay. So I would say just,
So I would have to just hire a lawyer?
I would say at least have a consult with one, at least go in and say, can you just sit down, you know, lawyer, can you just tell me, look at this and here are the list of, you know, assets that I, you know, these are the assets I believe are in the trust, because you're going to need to identify what the trust holds, what assets are in there. And that lawyer can at least give you guidance as to what your responsibilities are. And of course, I'm sure that you could hire that lawyer to assist you with that whole transfer process. Settling a trust can happen faster than that probate process because you don't have the same rules that you have to, you know, wait 6 months. You might still want to wait 6 months, but you're not going to be required to.
Wait, why would I want to wait 6 months?
Well, because very often you're not going to have all of your tax statements, 1099s and things like that generally don't get sent out until January, February, March timeframe. So until you have all of your tax statements, you're not going to know what taxes the trust might owe. And so you might want to wait until you know what all the tax statements say before you start distributing the property. I guess if you're the only beneficiary, that's not a big deal. But if you start distributing property to your siblings and then you have to go back to them 6 months later and say, oh, by the way, there were some taxes to pay, I need you to send that money back to me, that may not go so well. They might have already spent the money.
Like tax, like I'm so sorry, right? Like
income
like
tax.
Wait, what do you mean?
Income
like
tax.
On the house?
Income. So if your dad is the trustee of a trust and he's put his investments in there and he's got income coming into
Oh,
the trust.
And he just lives off his pension.
So it depends on what assets are in the trust and whether they're income producing. There's also estate tax that can be owed if your estate is over, like in Maryland, if your father's estate is over $5 million, there's estate tax.
No. Okay. Yeah. Sorry. And I'm in Florida, so we don't have that either.
You have no estate tax in Florida, right?
Yeah. Thank you. I was like, wait, why would I have to pay taxes? Okay. Thank you. And I do my dad's taxes, so I feel like, okay, so thank you very much. That was a great information.
Sure.
If no one else has their hand, I have another question, but I don't want to jump ahead.
We've got 2 more questions, and Danielle has shared her email address. So if we don't get to everyone's questions, I will share that in the post workshop email. So Umesh has been waiting patiently. Do you have a question?
I have not related to everybody, I can go last if you want me to.
Up to you. If you want to go ahead and pose it, I'm happy to.
Okay.
Press it.
So I'm actually a law student, second year, evening student with the University of Maryland, and I was wondering. I haven't even taken the state and wills course yet. I was wondering, for all of this, how much can I do with directly with preparing a document and notarizing it and keeping it safe, versus for much complicated. I think I might need to talk to a lawyer, or if I want a career in state and wills, what do you think that would help me?
So are you asking like what is helpful to get into this area of the law, or?
Yeah, one of the things that how should I get into this area of the law, and second, if I want to do it myself, what are the things I can do it myself, like financial power of attorney?
Sure. Well, I mean, I think there are programs in law schools now that actually are geared to probate and tax law and business law. I mean, those are the kinds of courses one would take, I think, if you wanted to get into this area of law. I think in terms of, preparing your own documents, like I said, there's forms that are, available on the Maryland People's Law Library website and Maryland Attorney General's website for like powers of attorney and advanced directives. I think those are intended to be used by individuals without having to hire a lawyer. I think when it comes to a will, I can tell you I've never been to like a LegalZoom website. But I do know that over a course of many years of practice, I have seen a number of do-it-yourself wills, and more often than not, there's an issue. And we've worked through, of course, every single one of them. But like someone just asked, for example, if I have a beneficiary on an account, do I want to list it again in my will? Well, the answer to that would be no, because that causes confusion and causes question about, whether the person, when they put you on the account, really did intend for it to be governed by the will. And so even though I know by law that the account trumps the will, it can lead to litigation. People, start that the person who did their own will really didn't know what they were doing. And so we need a judge to decide what should happen. So I would always caution people against about doing your own wills. I mean, you're not required to have a lawyer do a will, but if nothing else, there are, I guess, Maryland Volunteer Lawyer Services and other places that can do work for you on either a low bono or pro bono basis if you don't have, the income to afford a lawyer to do this for you. I don't know if that helps, but you can contact me by email, and I'd be happy to have further conversation with you about it all.
Okay, thank you. That's a good resource. All right, it looks like there are no more questions in the chat, and I know you have a meeting to go to.
Yeah.
So, thank you so much for joining us today and for answering all these questions. So I'm expecting that you'll see some follow-up emails, so thank you for sharing that. And thank you to everyone who joined us live today. It's always good to see a few students and reconnect. And I am looking forward to seeing you all in person soon. So get outside, enjoy this beautiful weather, have a good week. And hopefully I'll see you next week at the workshop on how do I negotiate my salary. Bye-bye.
Thanks, everybody. Bye.
Thank you.